Hello, good morning, good afternoon, and good evening, depending on where you are in the world, in the many countries and all continents watching this session. Welcome everyone to Data Scraping Can Be Useful, but is it a data breach, and when is it legal and ethical? This, in fact, is the first time we've addressed this subject, which has attracted wide interest. So I'm Stuart Dresner, founder and chief executive of Privacy Laws and Business, the world's most experienced information company specializing in this field, and now in our 35th year. Thank you to the many people attending who keep up to date with the help of Privacy Laws and Business International and UK reports published in alternate months in online, PDF and good old paper formats. For those who do not subscribe, information is at privacylaws.com/reports. Hundreds of people also download each of our Privacy Paths podcasts. We have released an average of one per month for the last 16 months, and the most recent one is Canada leads on applying privacy law to sales of recreational cannabis. The podcasts, not the recreational cannabis, are available on our website or wherever you find your podcasts. Turning to this session, I'm delighted now to thank Overy, the leading London based law firm, which has sponsored today's session, launching our autumn webinar season. If you have any questions for the speakers, please type them in the Q&A section, which you'll find on the right of your screen. So in the questions, not the chat. Type in the questions when you think of them, although the plan is to take questions after the presentations. A recording of the video of this session will be available to you after the session. Now, the moderator for this session is Karishma Brahmbhatt, who we can't see on screen, but we hope we'll be able to hear her voice later, or indeed we hope we'll be able to see her shortly. Explain about Karishma. She's the Data and Technology Senior Associate at Overy. In this role, Karishma specializes in all aspects of data protection and privacy law. She has particular experience advising companies, for example, on data ethics, artificial intelligence, big data, cookies, profiling, and Internet of Things. She wrote an article for PL&B UK report on how complying with GDPR's transparency and consent requirements causes a headache for the ad tech industry. And hello, Karishma. Oh no, you're Maeve. Hello, Maeve. Good to see you. And Maeve, you've been assisting in this. No, you are Karishma, aren't you? Yes.
No.
I'm not looking.
Yes, it's the wrong name, I'm afraid.
I'm trying to I'm trying to do too many things at once. Obviously, as we know, a man can only do one thing at once. Another speaker you see on your screen is Dr. Philipp Raether, Group Chief Privacy Officer at Allianz, the insurance company. In this role, he advises management on data protection issues worldwide, and is responsible for designing and implementing the firm's global privacy program. And the other box is our third speaker. Well, he's not the box, but he's our third speaker, David Smith, who's former Deputy Commissioner at the ICO, retired from that role about 7 years ago, and is now Special Advisor at Overy. David has spoken at our PL&B events for around 30 years and is the definitive data protection man for all seasons. Over the years, you've probably dealt with every significant data protection issue at both UK and European levels. So, if Karishma has not appeared, then we'll have to hand over to David and Philip, they will introduce this subject of data scraping. What is it exactly? Is it illegal and is it ethical? And for you, our audience, is your company a scraper or a victim of scraping? So over to David first, and then Philip will chip in. Unless maybe you're going to chip in as well.
We've got Karishma now. Hopefully, I'm keeping my fingers very firmly crossed, so I'll let Karishma carry on.
Yes, thanks, David. Hi, Stuart, and hi, everybody else. Hi, Philip. Unfortunately, because of a technical glitch, I am coming up under Maeve's name, but I am Karishma Brahmbhatt. So nice to meet you all.
Sorry for that confusion. I shall now disappear quietly until the end.
That's all right, Stuart. Thank you for the intro. So, as you all know, data scraping is one of those topics that most people have heard about. A few people know what the concept entails, but almost no one really talks about it. which is particularly interesting given that over the last 12 months or so, we've had a handful of well-publicized cases and regulatory enforcement actions that have brought data scraping issues to the fore. So in this session, as Stuart has mentioned, we're looking to demystify data scraping and to talk about some of the legal and ethical risks around the topic, as well as to have a look at some of the more high-profile cases that we've seen over the last couple of years. Now, we are going to be discussing data scraping from a European perspective, although, as you'll see a little later on, a couple of the cases and examples that we refer to do involve jurisdictions outside of Europe, such as the US or Hong Kong. Now, to kick things off, we do have a little poll for you, which should be appearing on your screens any minute now, hopefully. So if you could cast your votes, that would be awesome. Our starting question is, does your organization currently carry out any data scraping activities? And I'm hoping that this is coming up for you. It's not come up on my screen. Okay, well, if it doesn't come up, that's fine. We can crack on. Okay, we're having a couple of messages saying that the poll hasn't come up. That's totally fine. We will have a space for polls at the end as well. I feel like this is just one of those technologically challenged days for webinars. But if we go on to the next section, basically, data scraping is one of those, it's a powerful technique for collecting data and combining data that spans across various channels. Now, in practice, when someone refers to data scraping, they could either be referring to data scraping in its most general form, or they could be using the term interchangeably with one of its more nuanced variations, such as web scraping or screen scraping. Now, ultimately, all of these terms describe the process of data capture and extraction for different uses. And whilst they can sometimes be used interchangeably, that's not always the case. So it's really important that if you or your business are looking to engage in data scraping activities, you really hone down into the objective of the activity, as well as exactly what it is you're looking to do technologically to collect the data. Now, broadly speaking, data scraping itself refers to a process of using an application to extract structured information from various outputs. It refers to a technique in which a computer program captures data from output that's been generated by another program. So this means that in its broadest form, data scraping can involve the extraction of information from, say, a local machine or a database, and it doesn't necessarily have to involve the internet. Now, although it is possible to carry out data scraping manually, so by copying and pasting various bits of information, it's usually carried out using technology that finds and retrieves the relevant information. Now, there are two main branches of data scraping, as we've set out on this diagram. So the first one is web scraping, and web data harvesting is sort of analogous to web scraping. And for web scraping is basically the process of using an application that extracts structured information from a website. And the ICO in the UK, the Data Protection Authority in the UK, has actually described this as an automated process whereby content, which can include personal data, is scraped from a web page and stored for further processing. So to carry out the web scraping, you would usually use software bots to extract the data, because as you can imagine, it's a pretty time-consuming task if you were to do this manually. Now, the other main branch of data scraping is screen scraping. which is a bit more like a visual detector that scrapes information from a user interface of applications or texts from scanned documents. So to take a really simple example, there is an element of screen scraping involved when you want to, say, convert a PDF document into a Word document, because the technology reads what is on the face of the screen itself. Screen scraping doesn't really deal with the collection of data across websites. It tends to be a lot broader than that. And it is a form of data scraping that is typically used to retrieve data from legacy systems. Now, in this session, when we talk about data scraping, we are usually referring to the retrieval of large volumes of publicly available data from the internet. So we're basically talking about data scraping as it's applied through its web scraping branch. Now, once the data is extracted and combined into a more digestible format, it will usually be dropped into, say, a CSV or an Excel spreadsheet. And that data will then be used for comparison, verification, and analysis purposes to help the business to generate value and business efficiencies. So on the next slide, we've set out a couple of examples of use cases as to why people might want to engage in data scraping activities. So data scraping, and I guess in our context, more specifically web scraping, is also used in a whole host of other scenarios. So for example, for lead generation, where companies use the method to collect contact information about potential customers, or for e-commerce marketing, so that users can get pricing information for price monitoring purposes, or sentiment analysis as buyers' reviews are scraped. Now, data scraping doesn't always have to include personal data, but where it does, that's where the data protection laws come into play. Now, one of the most common misconceptions, I think it's fair to say, is that if data is publicly available, then it's fair game and you can do whatever you want with it. Now, as the lawyers amongst us will know, that is absolutely not the case. And there usually will be some form of restriction around what you can and can't do with that data. Now, broadly speaking, you will need to comply with data protection laws whenever you're processing personal data, and that's regardless of where you get the data from. So it's no different in the case of data scraping activities in particular. Now, in its guidance on the use of personal data in political campaigning, the ICO has said that in the case of web scraping, data protection law does not stop you from processing publicly available personal data, but you have to do it in compliance with the law. So, for example, if you scrape publicly available data from social media profiles, then you become the controller of that data, and you have to make sure that that data is processed in accordance with the GDPR and other local data protection laws. So legal basis for processing, transparency, purpose limitation, data minimization, these are some of the key data protection principles that will come into play whenever you are thinking about data scraping activities. And while I won't go through all of these here, there are a few points that are worth calling out specifically. So firstly, in relation to the legal basis. Now, as is the case with any processing activity, your purpose for carrying out the data scraping activity will be a key determinant in establishing what your legal basis for processing should be. Now, in most cases, legitimate interests will be the most applicable Article 6 basis for processing under the GDPR. Now, to rely on this ground, as you know, the processing has to be necessary for the legitimate interests of the person who's carrying out the processing activity, or the interest of a third party. so that those interests cannot be overridden by the rights and freedoms of the underlying individuals whose data is being scraped. And in practice, this assessment is usually carried out using a balancing exercise that weighs up the rights and freedoms of individuals on the one hand and the legitimate interests of the person doing the scraping or the third party on the other hand. Now, you need to be really cautious when the data that you're scraping could involve special categories of information, because whilst in limited circumstances, you might be able to rely on the Article 9 GDPR basis that the data has been manifestly made public by the individual. You will, depending on the purposes and the circumstances of the data scraping, you will likely find it quite difficult to establish an appropriate Article 9 basis. So in an ideal world, you would avoid scooping up any special category data as part of your data scraping activity. But if it does so happen that your net has been cast so widely that you could end up processing that data, just have a really hard think about what your legal basis there under Article 9 of the GDPR should or could be. The other point I wanted to call out on this slide was the purpose limitation. So as you know, this principle requires that personal data is collected for specified, explicit and legitimate purposes, and that the data should not be further processed in a manner that's incompatible with those purposes. So in practice, this means that if you are carrying out data scraping on websites, so web scraping, you would need to make sure that your activities are not incompatible with the purposes for which that data was put on the website in the first place. And as we'll see in some of the cases that David and Philipp talk about, organizations have been caught out by their failure to comply with this purpose limitation principle. Now, the fact that the fundamental data protection principles apply in respect of data scraping activities has been underlined and reiterated in guidance that's been issued by the CNIL, which is the Data Protection Authority in France, last year. So the history to this is that back in 2019, the CNIL had undertaken a series of inspections into the data processing activities of various companies to identify whether or not these organizations are processing data in compliance with the law. And what they found was, whilst a number of these organizations were using data scraping or web scraping to collect individuals' data from publicly available websites, this data was not being processed in accordance with the GDPR and the French data protection law. So, for example, they found that there was a lack of consent being obtained from individuals in relation to the sending of electronic direct marketing messages to these individuals on the basis of the data that had been scraped about them. And they also found that there was insufficient fair processing information or privacy notices that were given to the underlying individuals. So on the back of these investigations, the CNIL issued its guidance essentially by way of a reminder of the basic data protection principles and the best practice where organizations are scraping publicly available information, in particular for marketing purposes. Now, before we take a look at how the courts and the regulators have looked at data protection and other risks associated with data scraping, I do want to touch upon the topic of data ethics. So when we talk about data ethics, and I feel like data ethics has a bit of a reputation problem, when we talk about data ethics, we're really talking about the notion that just because you can use data in a particular way doesn't mean you should use data in that way. And data ethics has increasingly seeped into the mainstream consciousness over the last couple of years, largely in the context of AI. But actually, as a concept, data ethics is much, much broader than that. And it actually applies to all use, of all data. So it's technology agnostic. So it means that you need to think about data ethics even when you're not using AI. And the concept applies to, use of new technologies. It applies to use of or undertaking processing in the context of, say, ad tech and real-time bidding, but it also applies to activities such as data scraping. The other thing about data ethics is that it applies to all data and not just personal data. So often in data scraping activities, you'll end up sweeping up personal and non-personal data, but whilst the privacy considerations will pretty much apply to the personal data that you're processing, the data ethics consideration should apply across the board. Now, with regulators, activist consumers, and privacy rights organizations such as NOIB piling on the pressure to hold companies accountable for the way in which they collect and use personal data in particular, but just generally data, what this has meant in practice is that companies who do want to be a bit more innovative, a bit more out there in relation to the way that they collect and use data have had to be a lot more mindful about whether their proposed data-related activity could be perceived as being ethical. So there has been a lot of guidance that's been issued, again, over the last 3 to 4 years, in relation to the types of ethical principles that companies should seek to comply with in relation to their data-related activities. And this guidance isn't just limited to Europe. So, for example, data ethics-related guidance was issued in Singapore a couple of years ago, and most recently, the Ministry of Science and Technology of the People's Republic of China issued its new generation of artificial intelligence ethics code. So again, data ethics in the context of AI, but actually the principles do apply more broadly than that. Now, the challenge, of course, is that data ethics necessarily involves some element of considering the social, the cultural, and the political landscape in which you want to carry out a particular data processing activity. So here, it's the broader environment in which you want to carry out your data scraping activities, because you need to deduce what behaviors are and are not acceptable in that climate. Now, of course, these things are constantly changing. What was acceptable 5 years ago in terms of data processing, data use may not be acceptable today, especially as there is just more generally a wider appreciation of individual rights, and consumers in general are more aware of the types of processing activities that are going on behind the scene. But because these things are so fluid, it means that it's even harder for organizations to embed a concept like data ethics into the fabric of the organization. And this makes it one of the most complex risk management challenges that organizations face. Now, in case you're sitting there thinking, this is all wishy-washy, vague, hypothetical, idealistic, philosophical stuff, it might give you some comfort to know that data ethics principles are broadly aligned with privacy principles, by and large, and actually the reoccurring themes in the multitude of ethics-related guidance include concepts of fairness, for example, both in relation to data use and collection. They include transparency, they include privacy, they include accountability. So in practice, this means that regulators already have some very useful tools under existing laws, such as the GDPR, to penalize organizations for perceived breaches of data ethics principles. And in a way, we've sort of seen this manifest in the Cambridge Analytica scenario a few years ago, where the regulators clearly thought that there was something a bit off about the way in which data was being processed. and the processing activity just didn't pass the sniff test. But at that point, the regulators were able to use the data protection laws, and more specifically the GDPR, which had recently come into force, as a yardstick against which to measure the extent to which the organizations were acting in a way that's ethical, and to penalize for perceived lack of ethics in those processing activities. So that's the existing law, but actually we're also seeing a conscious move towards embedding data ethics principles in certain proposed laws, such as the EU's draft AI regulations. So I guess the bottom line for organizations who either are or are thinking of engaging in data scraping activities is to think about your activity more holistically and think about it in the context of, the data that you want to scrape, where you want to scrape it from, what you want to use it for, and also how all of those things combined would be taken or could be perceived in the context of the environment, the broader environment in which you want to carry out your data scraping. So on that note, I will hand over to David.
Thanks very much, Karishma. I'm going to look at some practical cases that have come before the courts and regulators, and try and draw a few lessons out of those. But I will be looking at them from a data protection perspective. So I'm really talking about scraping of personal data, not of anonymous or aren't all European, but where they're not, I'll try and say a little bit about how they might have been treated had they been in Europe. And I'll also look at perhaps a little bit about what the difference is between data scraping and a data breach. The first case, perhaps not surprisingly, involves LinkedIn, because LinkedIn is a favorite target for data scraping. And this company, HighQ, was scraping data from LinkedIn. LinkedIn had taken measures to protect the data. It had put in place automated or measures to prevent automated bots accessing the data. It had placed limits on the rate at which data could be extracted. And indeed, with this firm HighQ, it had gone so far as to issue a cease and desist notice. But nevertheless, when LinkedIn went to the US court to try and get an injunction to prevent HighQ from scraping the LinkedIn database, the court rejected that argument. Basically, it said that the data is publicly available. It's put there deliberately to be accessible to the public, and therefore you can't limit it. If it's accessed by the public, including HighQ, then that isn't an abuse. It's not a criminal offence, and it's not without authorization of the key words. So essentially, they found that there wasn't a problem with the data scraping by HighQ, although the case is still under consideration. What's interesting, I think, is that if you look a European perspective, I think you'd be much more focused on what HighQ were doing with the data after they scraped it, rather than why they scraped it. And HighQ are a data analytics company. And apparently there are two main reasons why they were scraping this data. The first was to identify employees who appear to be at risk of being recruited away from their current business, and then notifying their employers for a fee that this is the case, so the employers could take action. Now, that action might be wonderful for the employee. It might be to offer them a bonus to make sure they stay, or it might be to carefully manage them out of the organization on the basis we know they're going to leave. But either way, there's a big impact on the employee, and it's clearly personally identifiable information. To my mind, that wouldn't be acceptable in Europe under the GDPR, certainly not on the basis of legitimate interests. It would likely have to be only with the consent of the individual. But the other activity that HighQ were doing was summarizing employee skills in an aggregate manner and feeding that back to businesses to tell them where skills gaps are, and so where they're likely to need provide further training and support for employees, not on an individual named basis, essentially an analytical tool to assist businesses in filling skills gaps, recognizing and filling skills gaps. It seems to me that in many ways is quite proper. And although there are questions about notifying employees under European legislation, that is a sort of activity that could rely on legitimate interests. It's hard to see any downside for the individuals whose data has been scraped from LinkedIn. You might just ask the question whether it could be conducted with anonymized data rather than named data. But these very different uses of the data would attract, I think, in Europe, very different approaches. In this case, again, not surprisingly, is LinkedIn. Here, LinkedIn was scraped, data was scraped and put for sale on a hacking forum by a hacker who called himself Tom Liner. And although the word hacking is used and it was a hacking site, I would suggest that this isn't actually hacking. The personal data that was taken, names, phone numbers, and so on, came off the public-facing side of LinkedIn. There was no intrinsically private information, although this Tom Liner did add other information. So it was LinkedIn's information combined with other information as well. But as LinkedIn said, there was no getting inside their secure systems, alerting firewalls, or unauthorized access or loss. So again, it would be hard to say that LinkedIn did anything wrong here. This case came to the attention of a lot of data protection regulators, including the Italian authority, and the Guarantee said that LinkedIn is facing investigation by them, although we haven't heard any more since, and warned that processing of personal data deriving from this incident is prohibited by data protection legislation because such information is the result of unlawful processing. And I just sort of hesitate to say, maybe, is it? Where is the unlawful processing here? Although Tom Liner is a hacker, the access to the data wasn't unlawful. It's not clear that there's been anything unlawful done. So it's not clear that anyone who uses this data would necessarily be acting unlawfully. It's more about what they actually do with the information and whether that's consistent with the way in which it was made available on the website. And then we have, again, another case after LinkedIn, not surprisingly, Facebook. Again, Tom Liner, this same hacking forum, comes into to play here, who scraped all this data from Facebook's website, 530 million users, and posted it again online, this time apparently for free, not looking to make any money from it. And Facebook, again, said there was no hacking of their systems. Someone was using a legitimate tool, Contact Importer, albeit not in a way intended by Facebook, to extract information from the site. And again, it attracted the interest of the Irish Data Protection Authority, who started inquiries, although we haven't heard any more from them. What is interesting is that there's now been a class action. I hesitate to say it's actually been launched, but Digital Rights Ireland have been on their website encouraging people to join a claim against Facebook on the basis that was your data leaked in this Facebook data breach? And again, I hesitate. Look, this was scraping, but it was scraping of data which was deliberately made public on Facebook's website. It's hard to see that there was any data breach in this case. And it's hard really to see what the claims of the individuals would be. As far as we know, the data hasn't been misused. If it was, the claim would be against the people who misused the data rather than against Facebook, who who in some ways perhaps you might say the victims in this case. You come on now to perhaps sort of closer to home, to a French case where Nesta SAS is a startup that they offer food preparation and delivery services to workers. So you can sort of contact them and order what meal you like for your lunch and it'll be delivered to you. Perhaps this is a particularly French thing. I don't know. But of course, what Nesta were doing was scraping data from professionals on LinkedIn to then create a mailing list and it's an emailing list to contact people offering their meal services. And not surprisingly, the CNIL found against this. I mean, first and foremost, because people were being emailed with these offers of meals, and that was a breach of the e-privacy requirements because Nesta didn't have their consent to market to them by email. I mean, also other failings to do with the lack of information. What is again interesting is that Nesta argued they were a business-to-business service and therefore should be subject to less onerous requirements than would apply in the business-to-consumer context. Now, the CNIL rejected that. They said that messages about food preparation and delivery have little connection with the professional activity of data subjects who put their information on LinkedIn. You put your information there for professional purposes and professional advancement and making contacts, and food delivery's got nothing at all to do with that. What that leaves open is, would the CNIL have taken a less stringent line if actually Nesta had not been a food delivery organization, but perhaps had been offering professional training or signing up people to professional journals or membership of professional organizations, or perhaps not actually mailing people, not contacting people, not marketing people, but more doing analytics, market research based on the information, looking at how many people are based in the Paris region and how many are likely to be the sort of people that would be interested in Nesta's projects. Arguably, those could take place on legitimate interest grounds, even if what Nesta were doing here could not, which takes us nearly to the end of these cases. The next one, and one you may have heard of, is one from Spain, Equifax, which will be known to many of you, the credit reporting, credit reference agency, was scraping data from public records. So these are essentially, state or local authority records put into the public. So not social media in this case, as most cases are, but public records. And including that information, which was about people's outstanding debts, information published in the Spanish official Gazette and similar government sources, and essentially adding it to their credit files on the basis that it provides useful information about people's indebtedness and ability to pay. And there were complaints to Spain's Data Protection Authority, the APD, who basically found against Equifax and ordered them to delete this data, saying that Equifax had no legal right to use the information from these public records in this way, that they didn't inform individuals about, so no transparency that this information was being fed into credit reports, and that some of the information was outdated and inaccurate. And I think this is interesting because I suspect if the case came up in the UK, it might have had a different approach. I mean, it's very difficult to compare one country to another, but in the UK, the credit reference agencies get a direct feed of information about public county court judgments, debt judgments, and about bankruptcies. That's sort of an integral part of the system. Indeed, those records are made publicly available deliberately to sort of warn people that if they do business with individuals, they should know that they are subject to court debt judgments. Here, the Spanish authorities seem to have taken a rather different view, and a different view based on purpose limitation and incompatibility, and saying the reason the information is made available in these public records is to do with the right to effective judicial protection. And I covered a little bit of if we get my head around just what they mean, but they're saying the purpose behind making this available in the public record is quite different from Equifax's purpose of providing information about the financial standing and indebtedness of individuals. Incidentally, they also said that in some ways the information wasn't suitable, it wasn't necessarily accurate. There were people with the same names that couldn't easily be distinguished, and that the information may relate to historic debts which someone had now paid, and therefore it wasn't suitable. But I think what this illustrates is that although the similarities between what happens here and what happens in UK, the approach to data scraping and the use of information scraped from data may vary from country to country, and will depend on the sort of traditions, cultures, and background in that country, as well as on perhaps strict appliance of the data protection law. So lastly, I just mention a UK case. This is Ticketmaster. I won't really say much about it because, in my view, this is essentially a data breach case rather than a data scraping case. Ticketmaster put a chatbot on their site, and essentially that was infiltrated with malicious code, which enabled credit card details to be extracted, scraped from Ticketmaster, and some of that data was misused and was used to commit fraud. And although in its penalty notice to Ticketmaster, the ICO talked about data scraping, I mean, you had to commit a crime against the Commuter Misuse Act to get into Ticketmaster systems before you could scrape the data. So this is primarily a data breach rather than a scraping incident. And indeed, the data here was clearly unlawfully obtained, so would be tainted by anybody trying to use it. So I hope that's a summary of some current cases. I'll now move on and hand over to Philipp, who's going to talk about some of the other legal aspects other than purely data protection and privacy matters.
Sorry, I just had problems unmuting myself. Hopefully you can hear me now. Can we have the next slide, please? So what is now interesting, and David and Karishma have said that, to the extent we talk about personal data, data privacy laws apply. But over and beyond, there is more law because the courts, will look holistically at these cases. So what I'm saying now applies to both to data privacy cases, but also to other data scraping cases. So for example, if you were just to scrape corporate data, and we have a couple of cases about that. So the first thing which is at stake, I would call intellectual property rights. So what are intellectual property rights? I mean, the first ones spring to mind are copyrights, right? So certain data you may copy from one website to the others may be protected and then prohibited from copying. The thing is about copyrights, they need a certain threshold of originality or creativity. So often simply just data, as such, names and telephone numbers are not protected by copyrights. They need to be, embedded in a further story or something. However, Having said that, there's some other intellectual property right. It's called the database right. And the database right in the EU was really introduced by a database directive. In the UK in 1997 made that international law called the Copyright and Rights in Databases Regulation. And what are now these databases? They're simply a collection of independent data in a systematic way. And you can already see, to many information what would be on LinkedIn that is applicable, and you can only use that data with the consent of the database owner. Other IP, intellectual copyrights, are also trademarks, for example, right? And whenever you would now be violating database rights, copyrights, trademarks, you would be in the space of unfair competition because you're trying to get a competitive advantage by breaching these laws. So that is at stake at data scraping. And then there's a third element, which is also very important. We see in the cases I'm going to discuss are the contractual terms of the website. So obviously, if you publish certain information on a website, you make them typically subject to your terms, right? And if you're smart about it, you would say, okay, you can use that information, but only if you stay inside that environment of the website. If you copy them, especially for commercial use, we prohibit this by the terms of reference. So next slide, please. So there, perfect. So there is now another Facebook case here. This happened in the US in 2017. There was a smart provider. They were called Power Ventures. And then they had the idea, how about if we aggregate all the social media data of various individuals on a new website and all bring that together, right? So that you don't have to jump through various social media providers. Great idea, but obviously Facebook didn't like that competition and then sued Power Ventures in the US courts. They were saying it's violating their copyright, their trademark, also the CAN-SPAM Act, which is a Californian law against spamming, against the unauthorized access under the US Computer Fraud and Abuse Act, and 502 of the Californian Criminal Code, which also prohibits unauthorized access to information. Then you see on the slide, it went its way through the courts. The district court decided all the things Facebook is saying is right. And this was then also confirmed by the Ninth Circuit Court, which just says, okay, it's not spamming, but all the other laws apply. So you can see Facebook won here and awarded also damages, which Power Ventures then had to pay to Facebook. The next case is a European one. This is PR Aviation against Ryanair. And PR Aviation had here the great idea. They want to start a flight comparison website, bringing all the flight prices of various airlines together, right, on their website. But Ryanair said this violated their rights, and in particular, copyright and database right. So this case started in the Netherlands, and the highest court in the Netherlands actually asked the European Court of Justice whether this is a violation of copyright and in particular of the mentioned database rights. And as you know, under European law, if you have a question pertaining to European law, you have to ask at the European Court of Justice in Luxembourg. But interestingly here, the European Court of Justice was in favor of PR aviation. They said it's not a copyright because what I mentioned in the beginning, the level of creativity is not there with flight prices, no copyright. And they also said it's not a database right, because it's simply a airfare from A to B, so not a database, and therefore no violation of these rights. However, then ultimately the Dutch court decided on Dutch law, Ryanair would win that case anyway, and this was then done simply as their terms and terms of the websites have been breached, because Ryanair simply said the information on the website can only be used for private use to book tickets, but not for other companies for commercial use. And websites, you know, putting this data out are free to do that limitation. So you can see really well here, IP law hasn't prevented data scraping, but at the end, contractual law. And that's why I said in that triangle, it's very tricky to navigate, even if you get out of IP law, you know, there may be the contractual law or, you know, the privacy laws as in the beginning. So that brings us to the last slide, the summary, right? What we heard. So depending on your perspective as a listener to this webinar, you should take in mind if you're scraping data, right, you really have to look at the origin and nature of the data. Is it sensitive data? Is it not? Right? What are you using it for? But also if you don't really minimize the data. And then possibly, if that is achievable, if you're using that data, perhaps on the side you're using it, you can put out a privacy notice saying where this data is stemming from. And also what I would always recommend as a data protection officer, before you start the data scraping activity, start a data protection impact assessment to really see these, assess this data privacy risk that you're not running foul of them and are subject to litigation or compensation as we've seen in these cases. Then to the middle column, so what's also very popular is you're not doing the data scraping yourself, you're just buying it from a third-party service provider, but obviously you have to do your due diligence here, right? See, really make sure that this third-party service provider got the data in a legal way, maybe have also some representations in the contract there, because at the end, it's your responsibility, you using the data, and obviously have a data processing agreement in place. And lastly, this also might happen to you, right? You may be subject to scraping. So my recommendation is really do monitoring, right? And there are also third-party service providers to really monitor the scraping, but also open other channels that whistleblowers or your own employees keep your eyes open where their data could be scraped and replicated. And then last but not least, there are also technical measures to prevent scraping. You know, on the website, there are certain technical means to prevent copying, and this could be also a powerful tool. So basically, that's it in a nutshell. And now back to you, Karishma.
Thank you, Philip and David. So everyone, we appreciate that this has been something of a whistle-stop tour through the exciting world of data scraping. And we've basically been able to scratch the surface of the types of issues that you might come across. And as you can expect, the specific analysis will likely differ both from a privacy perspective, but also from an IP perspective and a contractual perspective as to where your particular scraping activity might sit on the risk spectrum and the compliance spectrum. We have had a number of interesting questions come through, so thank you everyone for that. As we only have a couple of minutes left in the session, I will pick out a couple. But if your question is not picked, please do not dismay. You do have our contact details, which are up on the screen at the moment, so feel free to drop us a line. So the first question, I think, David, is for you. So you mentioned the LinkedIn HighQ case, and the question there is, would it have made a difference if HighQ had logged in to a site like LinkedIn and obtained data once they'd logged in, rather than just scraping the publicly available data? Is there any sort of a privacy difference there?
Yeah, well, here's Karishma. Apologies again to everybody for my own scraping of the microphone, and I hope that didn't put you off too much. I don't know that it would make a lot of difference. No, I mean essentially in the LinkedIn cases, the organisations that scrape the data didn't do anything wrong in the views of the US court in scraping that data. So whether they simply scraped it or logged in and then took it, I'm not sure makes a great deal of difference. What would make a difference if you log in and get into data which is not publicly accessible, not generally made available to the public. You get some sort of privileged access to it, which wouldn't be available to any member of the public. And then you scrape the data and use it. Then you're likely to have obtained it unlawfully and will have greater constraints on how and if you can use it.
Yeah. And also, in addition to the data protection implications, there are contract implications as well, right? So if in LinkedIn's terms of use, in terms and conditions, they had precluded that type of an activity, then quite aside from whether or not you're compliant from a DP perspective, you may be in breach of contract in relation to the LinkedIn services. Next question is for you, Philip. So you mentioned due diligence of third-party providers of data scraping software and/or services. What type of due diligence would you carry out in practice? What types of questions would you be asking?
Yeah, that's a good question. But, the basis is the nature of what we discussed today. You would be asking, how you service provider did get the data, did you get it with consents, did you license it, or then how would you justify it, right? And then come hopefully to a conclusion that this data was gathered in compliance with data privacy, IP and contractual laws. So I simply would have them explain how they gathered the data and assure me that I can actually use them without violating the law, right?
Excellent. So I note that we are at time. So thank you everyone for logging in to hear us speak, and apologies for the technical glitches along the way. I will hand back now to Stuart to wrap up the session. Right.
Well, thanks very much. That was a really interesting session. I say the first time we've really got into this, and as you said, we're scraping the surface, and I'm sure we could come back to this another time. So thanks to all of you, Karishma, Philip and David, and you, the audience, for joining us. The video of this session will be available soon after this session has ended. We welcome your feedback and ideas for future online and live events. We look forward to keeping contact with you via our news, UK and international reports, events and podcasts. Our next webinar is sponsored by Linklaters and will take place on Tuesday, 9th of November. And the title is Navigating the Labyrinth of US Privacy Laws, Building a Compliance Program. Other webinars will follow in December and January, and we're planning a couple of live events in London in February and March. Looking forward beyond that, the dates for our 35th anniversary international conference are the 4th to 6th of July next year at St John's College, Cambridge, which we plan to make a hybrid event, so it will be accessible online as well. We look forward to meeting you there in person. Let us know if you want to propose a session, be a speaker or a sponsor. So thanks very much to Alan Overy for opening up this subject for us. We will certainly keep up with you and like to get perspectives and we'd like feedback from the audience. So that's all for now. Thank you and goodbye.
Thank you.